Welcome to Court Helicopter Explainer, where we are dealing with a no-go zone. A no-go zone because most people think it's a taboo to discuss this topic. Have you ever heard of what is called surrogacy? What is the law about surrogacy? People don't have children. How do you feel as a man if you have no child? Some communities regard you as a useless man if you have no child. What about a woman? Do you reach a time you feel you want your own child and your womb cannot carry that child? The scenario is medical. For men, the sperm count cannot be enough to make somebody pregnant. You cannot impregnate a woman. You're married to your wife, she wants to conceive, she is fertile, you are unable to impregnate her. Do you allow her to go out and get impregnated? You say no. You are the one who is wrong. You go to the doctors find you are the one who cannot give the seed to impregnate this woman. What about a woman? Sometimes it might be biological or a genetical mistake. You cannot conceive. 2, it might be because you overindulged in some vices when you are at the university and you affected your womb. Or they say not to marry. You did 10 abortions when you were a young girl and you lost your womb or your fallopian tubes. Or it might be you have some medical conditions, the hemorrhoids, the fibroids, all those things, they cannot allow you to conceive. There are people who conceive, but they miscarry after a certain time. You have tried to carry the pregnancy to term. You can't. Then you decide, I go to the hospital. The doctors tell you you cannot carry the pregnancy to term. Or you can never have a child. You are an old man. You are 70, 80. You have a young girl, young lady, 25. She wants a child. You can't. Then you say, what is the solution about it? You're a very old woman. Your husband dies. You have 3-4 kids who are big, but you have forgotten your new flame, your new love. He wants a child with you. You cannot get a child because you are beyond menopause. What is the answer of loneliness? What is the answer of childlessness? The law provides for surrogacy. Before we go to surrogacy, do you know if you sell your child, it is a criminal offense and you'll be jailed for 14 years. Do you know if you buy a child, it is a criminal offense and you'll go in for 14 years. So which is the way to have a child known by law? That is why we said it's a topic, taboo, but it's a serious topic. You have billions of money. When you die, who takes over those properties? You need a child. You have a big name. Who will carry your lineage? Who will bury you? The answer is on a new scientific method called surrogacy. This is what faced the learned court, the family court in Nairobi, in appeal number E034 of 2025. Because this is a matter that involves a small child, they are abbreviated AM and CAO. What is the background? By the memorandum of appeal dated, the appellant challenges the decision of the magistrate's court delivered on this date. In that judgment, the court dismissed the appellant's originating summons. Dated this, the appellant came to the High Court. What are the facts? The appellant is the man and the woman executed a gestational surrogacy agreement. A gestational surrogacy agreement. This is an agreement signed before conception. Conception that we need to discuss about this child. It was dated 30th of May 2024. The agreement facilitated an arrangement where the woman, that's the respondent, carried a pregnancy on behalf of the man. In the agreement, the parties agreed that upon the birth of the child, the woman could relinquish her parental rights and grant the man sole legal custody. These are the terms of the agreement. The child subject of these proceedings was born on 28th January 2025. And the father proceeded to approach the court for an order vesting him with the parental rights and legal custody to enable him travel back to his home country in the United States of America. The father is an American. The woman carrying the pregnancy is a Kenyan lady. So the child has been born. The father wants an order from court to go with the child to America. He attached to the summons, and in support of his application, he provided his passport, he provided his surrogacy agreement, and he provided the consent, which was signed both by the woman and him. He provided the birth notification for the minor and the consent of the mother, relinquishing her parental rights and legal custody, executed by the woman. He provided DNA reports confirming that he is the biological father of the child, and that the mother did not have a genetic link to the minor. What does this mean? The mother gave out her egg to be fertilized by the man's sperm. Mambo ya science. My team Bramwell are shocked. Also attached was a report from the Directorate of Children's Services dated 14th February 2025. The matter proceeded by oral evidence. Both the mother and the father testified. The mother confirmed that she was voluntarily relinquishing her parental rights and had no objection to the father going with the child. So, in the appealed judgment, the trial court observed that there was a glaring legal lacuna, as Parliament was yet to make a law to govern surrogacy in Kenya. As the court observed, then surrogacy is a reality in Kenya now. And therefore, pending the legislation, it fell on the courts to provide a solution. What did the judge deal with? The judge in paragraph 9 says, since this is the first appeal, the court evaluated the facts like this. I have summarized the proceedings of the magistrate's court. The facts can be summarized as follows. The appellant, who is an American citizen, entered into a gestational surrogacy agreement with the respondent, a Kenyan citizen. After birth of the child, with the consent of the mother, he proceeded to court seeking the conferment of parental rights and legal custody as an essential step to secure legal recognition of his relationship with the minor and enable him return to USA with the minor. His application was denied by the court on account of the tender year principle. The court vested legal custody in the mother. The respondent had earlier indicated that she had relinquished her rights. The consequence of the dismissal of the appellant's prayer, therefore, was that the child would be committed to a children's home. It was not contested that the appellant is the biological father of the minor. So the question at the lower court is, we cannot give a Muzungu a child who is of this age, tender years, a child who is a few months old. That child, the woman carrying it, you are the mother. Either take the child, if you don't, that child should be taken to a children's home. That is the decision of the magistrate. What did the judge say? Having considered the pleadings filed and relevant, I summarize the issues for determination to be whether the appeal has merit. The judge said, the Article 53 of the Constitution requires that in all matters touching on children, the best interest of the child be of the paramount consideration. The implication of the paramountcy principle on the application of the tender year principle was well and conclusively decided. He moves on to say, it is unfortunate that Kenya is yet to put in place the legislative framework that would govern surrogacy arrangements. Until then, the responsibility will rest with the courts to ensure that no person, male or female, married or single, who desires to be a parent will be denied that right, which technology has expanded. There is nothing on record to show that the appellant, that is the father, poses any risk to the minor. In fact, that the report of the Director of Children's Services recommended that he be awarded legal custody. I am persuaded that it is in the best interest of the child that the appeal hearing is allowed. On account of the foregoing, these are the final orders. The appeal is allowed in its entirety. The respondent, that's the mother, is deemed to have relinquished her parental rights. The father, who is the appellant, is granted sole parental authority and legal custody in respect of the minor. The registrar of persons is directed to issue the child with a birth certificate that reflects the father or the appellant as the father of the child. That is the judge of the High Court of Kenya. This is a judgment dated on 24th April 2026, last week. Critical issues are arising here. Can a mother be disconnected emotionally from her child that she has carried in her womb for 9 months? Uchungu wa mwana kaujuae ni mzazi. So the question that we are dealing now, we have a technology where conception is done in laboratories. We have now a technology where you decide the sex of your child. Do you want a boy? Do you want a girl? We have now the technology where people are determining the type of genes you want your kids to have. We have now a new conception where a man and a woman don't need to sleep together to have a child. Their genes are picked and taken by science. We have now test tube babies who are fertilized in the laboratory and they grow. So when you talk about technology, about the telephone technology, about the laptop technology, about the Wi-Fi technology, about the internet technology, about the electric border technology. We are talking about the super train technology. We are now dealing with that question. What annoys court helicopter is that there is no law. Kenya has not made this law. And this is a reality. Every day we are condemning parliament. We are condemning the women leadership. We are condemning the men leadership in parliament. Why can't we have the law governing surrogacy? It is a reality. It is now the in thing. Many of the Gen Zs who are saying they are not going to be married, they will have children through surrogacy. There is no law. Out of 10, we give Parliament 1 mark for failure to enact the law on surrogacy. Out of 10, we give the judiciary 10 out of 10 because out of the failure of Parliament to enact the law, the courts have taken it upon themselves to ensure that any parent who wants to have a family lawfully can have a family instead of going to buy a child, instead of going to steal a child, instead of going for trafficking of children. The courts, the High Court, has turned itself into a maternity wing. You can conceive by virtue of agreements and you can give birth, and the courts will become an extension of Pumwani maternity, an extension of Mama Lucy maternity, and we give accolades to the judge for allowing this child to go and join with the father who is an American citizen. Wakili Dan Stenomari, always bringing to you very controversial decisions, but very educative decisions that are coming out from the courts of this country.